Welcome back to the Law and Crime Network, Law and Crime Report. I'm your host, Bob Bianchi. The Laci Peterson's family is disgusted, stunned, and blindsided by a Supreme Court decision to remand the case back to the trial court to make a decision if there should be a new attorney. Let's listen to, throw to a clip of Peterson's attorney who appeared actually here on the Law and Crime Network.
Peterson filed this petition for habeas corpus in 2015, and the state court disagreed with 18 of the 19 claims. So this is primarily just a dispute about the juror who failed to disclose that she once feared for the life of her own unborn child because her boyfriend's ex-girlfriend was harassing her. What was your fear during trial? Was your fear that that juror might sympathize too closely with victim Laci Peterson, or was it just a fear that that juror lied during voir dire?
Well, look, this is what had happened. The Supreme Court first, as you talked about in the setup piece, just reversed the death penalty. So they have the option now of retrying the penalty phase. But before they got to that or made a decision, they now have issued what's called an OSC, order to show cause, to the trial court as to why the conviction should not be set aside. And you aptly put, they specifically honed in on this one issue, and this issue is a significant issue. We complained in real time 20 years ago that we kept exposing or finding what I called at the time stealth jurors, meaning jurors who were lying and had an agenda to get on here. And frankly, every single one that we identified was lying to get on here to convict him. We caught a couple of them in real time. This juror, we did not, but I was not as concerned about her at least when she was an alternate. When she, after the judge pulled off and eliminated a couple of jurors who had indicated that they were hung, she was placed into the jury, and she is obviously a troubled young woman. And the subsequent investigation showed that when she filled out the forms, she had absolutely lied about the fact that she had had a restraining order and that she had had an encounter with another woman. And that was exactly what another juror who we had found and exposed during voir dire had done. And then later, that other juror had admitted that she was lying to get on there to fry Scott. Her words, fry Scott. So this is a significant issue. Obviously, I've maintained for close to 17 years that Scott is innocent and that this was a mob verdict, and hopefully now he'll get the justice he deserves.
And Imran Ansari, our friend here at the Law and Crime Network, a former ADA and a criminal and civil trial attorney out of the Ayadela law firm in New York City. Imran, how are you today, sir?
Doing good, Bob. Good to see you, but good to be here.
Yeah, so what are your thoughts about all this? I mean, pretty compelling argument, a major disturbance. I can only imagine as a prosecutor what's going through my head right now after all that work, all that effort. A juror either lies or misinforms. There's the argument by the defense, and the Supreme Court is actually asking the trial court to take a look at it. What are your thoughts?
Yeah, no, listen, this trial was a really public trial. It was something that really captured the public attention. And I think everyone, including Laci Peterson's family, believed that it was a done deal. It was put to rest. They thought they saw justice in their minds, and this was a done deal. There was a conviction and then a death penalty sentence. But we now see how errors or perceived errors at the jury selection process could come back to haunt the prosecution years later, after a conviction, after the sentencing phase, if there was something done during jury selection. That's why you have to be really careful from the moment you get into that courtroom about what you say to a jury and what you do in that courtroom, because up on appeal, it may take all these years to really percolate up. We have an issue like we see now where things that happen during jury selection are coming back to haunt the prosecution.
Yeah, it's a terrible thing, and that's why you got to always be careful to protect your conviction. We also have Gigi Gonzalez with us out of Miami, Florida, a lawyer, a digital media journalist with a focus on criminal defense. Gigi, welcome to the show.
Thank you very much for having me, Bob. I appreciate it.
Yeah, my pleasure. So, Gigi, what do you think about this? And to Imran's point, I mean, prosecutors have to be very clean in how they try cases, but in this particular instance, this was to no fault of the prosecution. I've had this situation happen to me, never thankfully to a reversal of one of my prosecution convictions, but it's gut-wrenching. Your thoughts?
Oh, it's definitely gut-wrenching to the state and especially to the family. I mean, I'm sure both of them thought that this case had been put to rest already. And the fact that it's coming back based on whether or not a juror was impartial based on their answers in a questionnaire, that's tough, right? Because you want to believe that justice was served, especially the family of Laci Peterson. They want to move on from this. And the fact that this may be retried based on the fact that a juror was dishonest about a particular question a very important question on the questionnaire as to whether or not she was a victim of violence or not. It's very disheartening, and I can imagine the family is very frustrated here.
Yeah, and what do you guys think about the idea that these high-profile cases breed this scenario with all the media attention that people want to get on there for their 15 minutes of fame? Imran, this is a problem, one of many that I have when, these cases are played out in the court of public opinion.
Yeah, Bob, listen, I'm not going to get so into it, but we're having that very same scenario play out on the Harvey Weinstein case right now. We represented Harvey Weinstein in his criminal case, and there's going to be arguments made regarding something what happened during jury selection, and also a particular juror who ended up on that jury. And that is something which, on appeal will be argued in that case. And it's really something that we take into consideration here, how the public's perception of this defendant is, of the case. How much publicity did this case get going into trial, before trial? Because it's really something that we take into factor when picking a jury, because you want to avoid a juror who is an advocate juror, someone who has perhaps a motive to convict or acquit. And you have to avoid that, whether you be on the prosecution or the defense, depending on the case. You're going to want to avoid that advocate juror. You want someone who's going to be fair, impartial, with an open mind, and who's going to follow the law as the judge gives it to them.
Yeah, I think we've gone down a slippery slope of allowing far too much information out into the public. And I know the public wants it. I get it. And as journalists, we want it as well. But then we have to worry about the integrity of the convictions and putting families through something like this. Anyway, Scott Peterson, all the way back on Christmas Day in 2002, gave an interview right after his wife went missing. Let's take a listen.
Pretty much got all I'm going to do. Let's just go over what we already talked about so I can make some notes. See if you remember something that you don't. Maybe you don't know you remember it. So, today, just tell me about the morning.
Okay. I don't know what time we got up. Probably Laci got up and went and assumed she had some cereal for breakfast. She eats right when she wakes up, otherwise she gets sick because she's pregnant. I laid around in bed longer. I got up at, 8 o'clock probably or so. Showered. And we were watching her favorite show, Martha Stewart. Watched a little bit of that.
You didn't watch the whole thing, though?
No.
You remember what part you saw? I mean, I don't know what.
Some cooking deal. I don't know. Cookies of some sort. They're talking about what to do with meringue.
And I can't remember. Your house, you had the converted garage area. Is that your TV room, like? Or
Yeah.
Is that where you were then? Okay. Did you eat any breakfast?
Yeah, apple cereal.
When did you realize you were going to go fishing?
Oh, that was a morning decision. It's either go play golf at the club or go fishing.
Okay.
Seemed too cold to go play golf at the club, so just decided to 9:30 or whatever than that.
Mm-hmm.
Just told her what she was going to do for the day, and
Okay, so she told you what she was going to do for the day.
yeah.
And what was that?
She's going to finish cleaning up. Like I said, she's mopping the kitchen floor. Take the dog for a walk, and then she's going to the store to buy for Christmas morning breakfast tomorrow. and that was going to be involved prep. So that was her, just prepping breakfast, and she's going to make gingerbread cookies for tonight.
Well, okay, so all the way back there in 2002, let's not forget to advise our audience that he was convicted of first-degree murder of Lacey and second-degree murder of their unborn child, much of which was a circumstantial case. There's a lot of people who don't believe Scott Peterson, Imran, is guilty of this offense, and of course, there's many that believe that he is, but there's no real smoking gun. But I can't help but look at that statement that he's giving to the police and think to myself, as a former homicide prosecutor, wow, if I got to try this case all over again, it's never better. It's never better for the prosecution on the second go around. The defense attorney knows the prosecution's theory of the case. The defense attorney has all sorts of transcripts to cross-examine witnesses whose memories will fade over time. Witnesses get lost. What are your thoughts about what prosecutors are thinking right now, Imran, having been one yourself?
Yeah, if you have to retry a case, it's always a different scenario. Your cards have been shown. The other side is prepared. They know what sort of cross-examination you're going to be putting on, or evidence, I should say, putting on the people's case. They know what arguments you're going to be making to the jury, and they know how to counter that. So when they prepare their cross-examination of the state's witnesses, they're going to be all the more prepared for what you're going to throw at them. But there's also a concern here. A lot of time has passed since that original trial. You're going to have evidence that may have gone stale. You may have witnesses who are not available anymore. And those are circumstances and considerations that the prosecution is going to have to take into consideration when looking to try this case again, if they have to. Also, the family's been put through a lot. They lived through it one time, and I'm sure they don't want to do it again. And that's perhaps the biggest consideration the prosecution has is, the concerns of the family. And in a scenario like that, often the prosecution, I'm not saying it's going to happen in this case, but often the prosecution will offer a plea deal and see if they can plea it out rather than retry the case.
Yeah, Gigi, what are your thoughts about that with your criminal defense background? If you were the criminal defense attorney in the case, and it could be right now, before the judge actually holds this hearing, that you may want to approach the prosecution and say, look, the death penalty got reversed earlier this year. Now we're back at this. We think we have a really, really good argument that this conviction is going to be vacated. It's going to be reversed. We believe we can at least get one juror to hang, if they will, or at least not find them guilty because it was a circumstantial case before. As a criminal defense lawyer, do you make an approach to the prosecution before this proceeding even begins to say, let's end the bleeding?
Yes, absolutely. And the defense here is in an exceptional position to be able to do that for all the reasons you said. There is a pretty good shot that this conviction is going to be overturned based on the one appellate issue that they, were able to be successful on. Is this juror able to impartially review the facts? And the facts are of this juror is that she was faced in a similar situation as the victim in this case, where she had to file a restraining order from her boyfriend. I think that's a very compelling piece of evidence that would suggest that this juror was trying to be an advocate juror. So there is a good shot. And I think it would behoove the defense to come to the state and try to resolve this in a way that is amenable to the victims and also, successful for the defense.
Imran, real quick, what are your thoughts in terms of whether or not, if this goes to Gigi's point, and I believe the juror number 7, also was pregnant at the time and indicated, at least there's some news accounts of this, that she was concerned about her unborn child. That's pretty close to this case. What do you think happens in the end analysis? I won't hold you to it, but what are your thoughts?
So I think that, in the event that it is overturned and the conviction is actually set aside, then I think the prosecution is going to do a long, hard look at whether they're going to put this family through that trial again, whether their evidence is still fresh and not gone stale. And when Mark Garagos comes knocking on the prosecution's door, they may be willing to talk a lot more than they were willing to do when this was come to trial the first time around.
Wouldn't be the first, nor will it be the last time. I've heard it personally myself on many occasions where the family just says, enough, we can't take this anymore. Great commentary, guys. Really appreciate it. We got a lot more coming back on the other side of the break. Stay with us. We'll be right back. All right, welcome back. I'm your host, Bob Bianchi. So we've been talking about the bombshell developments in the Scott Peterson case. prosecutors have got to be on their heels with respect to this. Let's listen to Donna Provenzano, who is the supervising deputy attorney general.
Now, recognizing that this court may disagree with respondent about any one of those, and should that be the case, respondent likewise acknowledges that this court has made abundantly clear since the time that the parties have filed our briefs in this case, that if there is even one erroneous excusal under wit, the remedy is to reverse the death judgment. And in fact, as recently as last year, in this court's decision in Armstrong, People versus Armstrong, the court said, and I quote, "The rule is not ours to revisit," unquote. And so respondent wishes the court to know that we understand that if that were to come to pass, and this court would reverse the death judgment based on an erroneous excusal under wit, that this court is compelled to do so under the authority of the United States Supreme Court in Gray versus Mississippi. In recognizing that, respondent does not intend to pursue that point with the court today, but we stand on the arguments that we made in our brief. Opposing counsel is correct. Respondent believes that this question under the Eighth Amendment has been answered by none other than the United States Supreme Court in Witt, which made very clear that erroneous excusal under that standard is governed by the Sixth Amendment, not the Eighth Amendment. And the very case that's driving this train, if you will, Your Honors, on this first claim, Gray versus Mississippi, there is no mention of reversing the guilt phase verdicts. And this court in Armstrong last year made clear that there is no reversal of the guilt verdicts if there's an erroneous excusal for cause under wit. And so respondent's view is this question has been soundly answered by this court and the United States Supreme Court.
Okay, Imran, let's go to this. Making a distinction, prosecutors are about the reversal of the death sentence versus a reversal for the actual verdict of capital murder. Okay, so they're two distinct things. From what I'm understanding, and you tell me if I'm wrong, they're basically saying there was a juror selection problem in the jury selection with respect to the death penalty, and that is the reason why that got reversed. But what she's trying to argue, that does not necessarily mean the guilt conviction should be reversed as well. Are you hearing that the same way I am?
Yeah, and she's citing to the case Witt, which is a United States Supreme Court case. And she's using that case to argue that although the court was able to reach a decision that the death penalty phase can be overturned and that death penalty sentence overturned based on a juror issue, and that would be a presentation to those jurors that if they were against the death penalty, they would be excused. It didn't go further and ask if those jurors could keep an open mind and follow the law as the judge instructs it to them, even if they disagreed with the death penalty. But she's making the argument that there's a distinction. Although that case authority allows the court to overturn the sentencing phase, it doesn't allow the court to then go back to the conviction phase and address that, despite a perceived or argued juror issue, as Garagos and his team are doing for Scott Peterson in this case. So she's making the distinction from that Supreme Court case that, yes, you could go back to sentencing, but no, you can't go back to the conviction phase.
Imran, doesn't this come down to the old legal theory of trying to thread a needle?
Yeah, but the defense is going to be trying to thread that needle, right, Bob? And I think it really is interesting that the courts are even considering it, right? They're looking at this question regarding the juror selection phase in the trial itself, and they're keeping an open book, so to say. Now, the state has enough time to come back, I think, in November, early November, their opposition to this is due. And the fact that the court is considering it really shows that the court is giving some open-mindedness to the defense's arguments as to that conviction case.
Yeah, but you know what I don't get with this. Let's just take Scott Peterson out of it. Let's just look at any ordinary trial, nothing of any great magnitude. Let's say it's a theft case and there's a conviction and it goes all the way to the Supreme Court on the issue that there was improprieties in the jury selection and that one of the jurors lied about knowing the defendant or knowing the victim in the case. I can't imagine that the Supreme Court of a state can't say it needs to be remanded back to the trial court to find out if in fact that is accurate and then to find out whether or not that would have had an impact on the jury. I don't see this argument being made by the government right now that the Supreme Court can't have them just go back, regardless if it's a death penalty case, to review whether something wrong occurred during jury selection in any bland Jane Doe case. What do you think?
No, absolutely. When you have a compelling set of facts or allegations, such as the scenario, the hypothetical you just presented, Bob, I can't see the court allowing a conviction to ride on a jury issue like that. I mean, that would be a fundamental issue with jury selection that would go to the crux of a fair trial for that defendant. And I think that's what's being argued here. And that's the sanctity of our system, right? That a defendant is entitled to a fair trial with a juror of their peers. And that process of jury selection is so sacred that if there is any taint in the jury selection process, I think the court is going to be careful, err on the side of caution, and they're going to allow the ability to go back and really see if there was any taint in that jury selection process.
All right, great. Hey, listen, guys, we got some breaking stuff here. Danny Masterson from that 70's show Star, who was charged with raping 3 women back in June of 2020 for incidents that had occurred in 2001 and 2003. He requested a probable cause hearing to see if those charges should be dismissed. The judge allowed them to at least make the argument there should be that hearing before he would have to enter a plea. They are in court. He has waived. That is, the defendant, Danny Masterson, has waived his appearance to be in court. Let's take a listen.
That these cases are so old that they have outrun the statute of limitations, which was, whether you find it to be 6 or 10 years, would have expired at the latest at the end of 2013. Under 261A2, this case is no longer able to go forward, and this court just does not have jurisdiction. So we would ask for this court to sustain our demur and to dismiss the case. Okay. People?
Your Honor, first of all, one needs to look at the statutory language under Penal Code Section 799, which dictates whether a felony offense can be commenced at any time, and that is, in part, if an offense is punishable by life imprisonment. Now, the language under 799 refers to an offense punishable by life imprisonment. So now, the argument becomes, under Turner versus under Perez, is there a distinction between whether the offense itself is a life sentence, punishable by life, or is it whether there are some other circumstances that would dictate that? For instance, in Turner, they were talking about the 3 strikes law. They were very specific. They narrowed it down. It really had to do with the fact that there were prior convictions, that the defendant had prior convictions, which enhanced the substantive term on that particular offense. Perez distinguished Turner by specifically stating, and by the way, the facts under Perez were factually very similar, with the exception of the fact that there was in Perez, there were multiple 288B offenses, versus here we have multiple 261A2 offenses. But otherwise, it was beyond, the offense itself was beyond the statute of limitations, but for the fact that there were multiple victims. So Perez looked at it very carefully, and it made a very, very narrow distinction, saying that, and it was a very important distinction, that the difference between an enhancement under prior convictions versus a separate sentence scheme or a separate sentence under a one-strike law, in particular to the multiple victim enhancement, is distinguishing. And what they looked at is language saying that in the present case or cases under Penal Code Section 667.61 under the multiple victim enhancement, it talks about multiple victims, conviction of a multiple victim in the present case or cases. So we're not talking about some prior convictions. We're talking literally about the offenses in the present case or cases. So if you've got more than one charge in the present case that falls under the 667.61 sub C section, then the 15 to life then kicks in for that particular offense. And it's also clear, if you look to the statutory language and the legislative intent, if you look under the California bill analysis that was argued and discussed on the Senate floor back in 1993 and 94, they specifically talk about how the one strike is different in that this is to impose a life sentence on the particular offense itself rather than a life enhancement that you would see under some other, like for prior strike convictions. So the California legislature, when they discussed this, they were very clear about wanting to make a separate crime, in essence, punishable by life sentence.
It may be complex and not sound very whatever, but it's very important to this case. Danny Masterson, that 70's TV show, lawyers arguing as to whether this case will be going forward or not. We got to take a quick break here at the Law and Crime Network, but we'll be right back. Okay, we are back live in Danny Masterson, that 70's show stars motion made by the defense attorneys to dismiss this case. The lawyers are making the arguments in court right now. Let's go back to court.
If there was more in that particular case, in that particular filing, on the four corners of that document, there is more than one victim that is alleged. If that is true, then that would fall under Penal Code Section 799, subsection A, and therefore it is there's no statute of limitations, so people can file it under certain guidelines, certainly, but there's no 5-year, 6-year, 10-year statute. So looking at the four corners, the charges are there, plus the charge of the allegation of 667.61B, E, and 4. Now, you're right, both sides have pointed out there are two cases. The Turner case, first of all, happened in 2005. That dealt with a robbery, dealt with the three strikes law, and both of you have accurately kind of set forth what that is. And in that court, they said the statute of limitations excludes the time for enhancements. And you're looking at, it's for the three strikes law, is for an offense, and not for the offense, but applies to the offender. So here you have a recidivist type of individual that has committed multiple cases that constitute strikes, and our legislature had decided that if you do this, then you're subject to this three strikes law. Now, Perez came out after Turner. Perez happened in 2010. And Perez specifically addressed Turner. It specifically addressed it in the body of the case. And Perez is almost on all fours with this case. It is a situation, albeit it's 3 counts of lewd act on a child, and our case here is 3 counts of forcible rape, but those are the statutes that are governed by, or you can enhance but pursuant to Penal Code Section 667.61B, E, and 4. So in this situation, 3 different victims and that allegation under what is commonly referred to as the one strike law. They specifically addressed Turner. Turner is factually dissimilar in light of the fact that the 667.16 was not charged in Turner. Also, it was a robbery, not a sex crime. So factually, Perez is certainly more on point than Turner. They also stated that Turner should be narrowly construed to only apply to 3 strikes. 3 strikes, again, goes to recidivism. The 1 strike does not. And it looks just at the 1 charge with regard to it. And the penalty would be imposed based entirely on facts and elements proven in this individual case, not on prior convictions. So that also is something the court looked at. So I don't see that there is necessarily a split in authority, and I understand why you're saying it, because they're both determined to be alternate sentencing schemes. However, when looking at Perez compared to Turner, Perez seems to lay the groundwork what the court does, or gives me guidance what the court to do when a 667.61 is alleged. So with regard to that, because it is alleged and you have the 3 victims, I believe there, Penal Code Section 799, subsection A, there is no statute of limitation. So therefore, their motion based on lack of jurisdiction because of beyond the statute, that is denied. Now, you also go in your moving papers, and I wanted just to quickly address it because it is in the moving papers. Initially, you said it's a due process violation on the 5th and 14th, but if you look at Penal Code Section 104 or 1004, that's not part of the grounds. I understand that's an umbrella that goes over a case, and in your moving papers, you argue somewhat of an ex post facto type of scenario, but I don't believe we have that here. Penal Code Section 266.61, that was enacted in 1994, so that was before the cases here. So it's not like the cases here happened and then that enhancement was added. So that argument doesn't fly. Then there's a motion to dismiss, and you cite Zamora and some other language that you use, at least in your initial demur, that lack of due diligence in the investigation, the witnesses have died, memories have faded, exculpatory evidence is lost, and therefore the defendant has been prejudiced. Then in your reply, you say, well, wait a minute, I'm not really making that argument yet. So there is no just kind of general due process argument. So I would deny it on that ground. But without prejudice, obviously, because you pointed out a lot has to be done in this case with regard to that. Then also you cite Penal Code Section 803F2. That applies when a child is involved. So that has no bearing, because I think 3 or 4 lines before you make that argument, you note that the individuals in this case were adults. So that doesn't apply, and that's about requesting an evidentiary hearing. So then also you point out that Zamora grants the court discretion to do an evidentiary hearing. I respectfully reject that argument. I just don't think in this particular case, based on how the court has just ruled, an evidentiary hearing is necessary. You'll have a chance certainly to have a preliminary hearing or whatever vehicle the people choose to do. And then if ultimately gets to trial, then that's when an evidentiary hearing certainly will be flushed out. So for all of those reasons, I'm going to deny your motion for demur. Also, I'll deny your request for evidentiary hearing. Then at the very end, you ask, for specific information from the people. I'm going to let you all work that out amongst yourselves. So I don't need to get involved in that. That's not in my wheelhouse. So
it's getting harder to do legal commentary when you can't be a lip reader anymore. I know that audio is a little difficult, but both of you guys, I believe, based on the notes that I have in front of me right now, from a little bit of what I was able to clearly make out is going on here, is that it's a statute of limitations argument that I believe is they're saying should have expired for all the offenses, anybody, period, end of story, by 2015. the prosecution, but there is no statute of limitations for a punishment that has a light sentence attached to it. The one strike law does not apply a separate statute of limitations, nor does it supersede the statute of limitations. I know this is really heady, is the argument that the defense is making. But because of the extended term he could get based on the offenses charged, the government argued and the judge agreed that the statute of limitations it was expanded. It's the best I could figure that out. Imran, how about yourself?
Yeah, I think that was the crux of the defense's argument on demurrer, which is a vehicle often used in civil cases, not necessarily as common in criminal cases. But what it was saying, their argument was, as you stated, Bob, that there was a jurisdictional problem here because the statute of limitations, the SOL, if you will, had expired. But the state countered that, pointing out that one of these charges, at least one of the charges, was a rape charge that is punishable up to life in prison. When that is the case, the statute of limitations is done away with, and that is a charge that could be brought no matter how many years have passed. And I think what we hear here is the judge has sided or agreed with the state. She's not going to be dismissing the charges. She also she dismissed without prejudice one of the arguments that there may be some due process issues with stale evidence or lost evidence and witnesses who have passed away, saying it's not ripe yet for consideration, but she dismissed it without prejudice. That means that if some of those arguments come to ripeness during the trial or after the trial, then the defense has the opportunity to then apply that argument for the judge, and she may consider it. And there was another argument that they wanted an evidentiary hearing based on a certain charge. However, the court was pointing out to the defense that she won't grant the evidentiary hearing, and that section or that statute applies specifically to criminal charges related to misconduct against a child. Here, Mr. Masterson is not alleged to have committed any crimes against a child, so she didn't give the defense that evidentiary hearing that they asked for.
Yeah, excellent breakdown. Gigi, every defense motion has been denied up to and including allowing cameras in the courtroom, which the defense tried to have excluded. So pretty much a blow to all the defense's arguments. And I think to get to Imran's, one of his last points there was these evidentiary hearings. We all know as defense lawyers, you want to get evidentiary hearings because it allows you some free cracks at some witnesses and to dig deeper into the testimony. The prosecutors call that a fishing expedition. It can be very helpful for the defense, but the judge is having none of it. What are your thoughts about the judge's ruling, which of course now leads us to the point, because Masterson is not in court because he waived his appearance, where we presume he's going to enter a plea of not guilty?
Right, exactly. It's definitely a good presumption to assume that Masterson is going to plead not guilty to this. As far as the evidentiary hearing is concerned, I think it'll remain to be seen. We're going to have a lot of discovery in this case, hopefully. And from there, I think the defense will be able to better cater their arguments and their strategy moving forward. And you're right, it is a bit of an fishing expedition, but it's important for the defense to know what it is they're getting themselves into. That way they can form a proper defense to prepare for trial.
Yeah, no question about it. And some folks may think that, oh, this is crazy. Why are they doing this? They can never prevail. The bottom line from the defense perspective is you've got to make the motions, even though you may lose them, to preserve the record, because you never know, Scott Peterson trial, to be exact, what down the road could lead to an ultimate reversal of any conviction. Guys, we got to take a quick break here on the Law&Crime Network. Don't go anywhere. We got more for you. We'll be right back. Welcome back to the Law&Crime Report. I'm Bob Bianchi, your host. I've been wondering for a very long time, years now, what happens when a man with a lighted torch confronts a Seattle police officer? Let's take a look.
All right, he's going to be in the alley just north of Denny Park, on south of Westlake, to the east of Dexter. He's just walking down the alley southbound with the stick on fire, and it is very on fire.
Alley north of Denny Park, south of Westlake, east of Dexter, walking southbound.
Hey, Seattle police, stop! Seattle police, stop, dude!
Shots fired, shots fired. Do the stick at me.
Finally have my answer. So this gentleman tells the police to F you. The cop goes to move his vehicle closer to the individual who's going more into an area of where there's more activity in the community, spins around, goes towards the officer, jams that torch inside the police officer's vehicle, which was substantially burned. As a result, the cop had to escape by going outside the passenger side of the vehicle, but the officer fired a number of rounds, none of which hit the gentleman. Thankfully, everybody was quote unquote safe in that situation. Gigi, again, this gets to a point. I'm sure it'll be debated why the officer fired his weapon and so on and so forth, but these things are happening instantaneously. The person clearly, in my mind, is erratic, probably has some mental health condition. We talk about this all the time. But nevertheless, the officer does have a right to defend himself. Do you find this is going to be considered a good shoot or a bad shoot?
I think down the line, he's definitely justified in trying to protect himself, okay? There's someone who's walking around with a lit torch and shoved it into the driver's side of his vehicle that he was operating at the time. So he's going to be good on the justification that his use of force was reasonable. Now, whether or not it was reasonable to unload his gun while smoke engulfed the vehicle, preventing his sight, that's another thing to debate. But I think that we could see very clearly from the body cam video that he was attacked and it was an unjustifiable attack, and the police officer is most likely going to be considered reasonable for his use of force here.
Imran, what do you think about that, or any other general thoughts you may have? Because, there's not too many torch lighting, attacking an officer cases that I've ever seen in my career.
Yeah, no, I agree with Gigi. I think this is going to be they're going to do an investigation in Seattle. Seattle PD will look into the body cam footage. They'll look into, the account from the officer. And I think they're going to come to a conclusion that this was a justified shooting, because it's so bizarre. First of all, you have this guy walking down the street with a lit stick, if you will, and he charges that RMP. That's what we say in New York. It's a patrol vehicle. He charges that like he's on a horse jousting like a knight, and he's going directly to that officer's car. He puts that flaming stick into the car. I think that officer had every reason to believe that there was deadly force being used against him, and he had to counter that with deadly force. Thankfully, no one was hurt in this incident. But when it comes down to reviewing whether this was a justified action by the police officer, I think that he's going to get a check, and that means that he was justified in countering that lit, flaming, jousting individual with a shot.
Our good friend, Professor Kirk Burkhalter, and I were discussing this. I mean, I'm beginning to wonder whether or not they should be having mental health professionals roll on every scene. It can help in some instances. This it couldn't. There's no question in my mind about that. It happened too quickly. But what are your guys' thoughts about either getting officers seriously trained in mental health, not this case, but in other cases, or having them rolled? Because I'm finding with less and less services that are out there for these folks, and the fact that their mental health care is better taken care of in a jail, unfortunately, than in a mental health facility, we're seeing more and more of this. Give me your real quick thoughts. Gigi, I'll start with you.
Thank you. I think that we would be better served by having a department or an agency that is trained to resolve these types of matters. Right now, police officers are expected to resolve everything from murders to traffic tickets, and we really should be allocating funds to develop agencies to address these types of mental health issues that we see so clearly in these types of cases.
Yeah, and Imran, that's, of course, if you could have gotten to that gentleman before he lit his torch on fire, because again, I repeat, in this scenario, the officer doesn't have to say, oh, he's got a mental health issue. The fact of the matter is it happened very quickly. There was no time to intercede and the guy's life was in danger. But what do you think about a general idea of expanding those mental health services to actually ride along the police when they have those situations, that they can intercede?
Yeah, but I mean, to the point